Okay, hello everybody. Good evening here in the US and magandang umaga sa Pilipinas. Mayong buntag in Mindanao and the Visayas portion of. So just give me a little bit time to just share the live event today. So basically our topic for today is about the recent new guidelines of the no objection statement released by the EVP Philippines, and we'll talk about what it means to the Filipino teachers and professionals in general. The reason being I said that because hindi lang naman limited to the teachers ang J1 visa, but it also applies to researchers or other professions. Though commonly, ang maraming nag-avail sa J1 program natin are teachers from the Philippines. So just give me maybe 2 minutes lang to share the event, okay? So may nakikita na ako na angry emojis, but I know they don't hate me, but maybe about the topic, but let's talk through them though. So para mas maintindihan na natin where the EVP is coming from and what we can actually do about it, no? As a participant or a future participant of the J1 visa program. Okay, so hello everybody. This is Nick Caracal from New York. I will be talking about this particular topic. But as we actually move further, I will be actually zooming in the PowerPoint presentation slides that we'll have, so you can actually follow me through the slides that I will be showing you. So the topic for today is EVP's new guidelines for the no objection statement. What has had change? We'll talk about the old guidelines. So people na bago dito sa J1 visa will be able to understand bakit big deal siya, kasi ito yung old rules nila and how the new J1 participants now be able to comply with or avail of the new guidelines for the no objection statement. So among all the J1 waivers, the no objection statement is so far dati the easiest, the less costly, and the fastest way of getting a waiver. So we'll start with the presentation slides. Okay, just a reminder though that this is actually, this live is actually intended to share information, and this is not intended to actually create an attorney-client relationship, but just for me to be able to answer your questions. Kung may mga tanong kayo, isulat nyo lang sa comments section and I will be able to respond to them. So again, hindi ko na isa-isahin, But magandang umaga po sa inyo lahat dyan sa Philippines and magandang gabi naman dito sa United States. Okay? Just to understand where we are actually coming from. So, the rule that requires all J1 participants or visa holders subject to the 212E. So, this is the Immigration Nationality Act of the United States, Section 212, Section E, that it actually says that no person, and ito na yung mga J1 participants natin, who are actually stamped. So, kung titingnan nyo yung visa stamp nyo na nakasulat that you are subject to the 212E, or kung titingnan mo yung form mo na DS 2019 at naka-check mark yung box na you are subject to the 212E, it only means that you cannot apply for any non-immigrant visa. So even if you're gonna apply for J to a tourist visa or from J to a student visa, much more if you'll be applying for an H1 visa, which is basically the specialty occupation visa, or for an immigrant visa, tinatawag natin na green card, you will be required to prove to show that you've been approved of a waiver or that you have complied with the 2-year home residency requirement. Ibig sabihin that after the program, you have to go back to your most recent home country of residence or kung saan mo nakuha yung J1 visa mo before entering the United States. Okay, so we're gonna jump into the conversation of ano-ano ba bang klaseng waivers available for you. So let's start with the U.S. Department of Homeland Security's basis of providing waivers. So there are 5 grounds to avail of a waiver. The first one is the no objection statement. As I actually mentioned earlier, ang pinakamabilis, ang pinakamadali so far before at saka pinaka-less costly to get a waiver is the no objection statement. The no objection statement is applied at kung saan man galing yung participant na yon, they're gonna apply it from their government. Because in this case, for the Filipino teachers, we have to apply from the exchange visitor program in the Philippines to apply for a waiver. So again, a waiver means that you will be forgiven or not required to go back to your home country so that you could apply for another non-immigrant visa, in particular the H visa, or apply for the green card. Second is the request by the interested U.S. government agency. So maraming nagpapaset ng schedule sa amin for consultation, which we decline, or at least we give a refund to those who are inquiring about the IGA or IGA as you call it. Kasi as of now, the U.S. Department of Education US is actually saying that they are not planning to accept any application for a waiver. So we've tried to actually reach out to them and even the Bureau of BIE for the Indian schools, and there are no response from those agencies. So in particular for the teachers, the applicable federal government agency that may be interested in filing waivers for you will be the Department of Education. So the difference between the IGA waiver is that on an NOS, it's actually the applicant who will apply the waiver or file the waiver application. In the particular of the IGA, though, it's the employer who will file on behalf of the applicant for the waiver. But of course, this is a different conversation between ikaw yung nag-a-apply, in the case of the NOS, and when the employer applies for you. So it means that yung employer mo sobrang impress sa'yo, or that your contribution to the school's performance has been so significant to the extent that the employer will take an extra mile to file that waiver for you. But again, as of now, the Department of Education is not accepting a waiver application based on the IGA. Persecution, ito yung when your life is in danger. If you go back to your home country, then you might be able to apply for persecution with the Department of State. Number 4, which is the second most popular among the waivers, is exceptional hardship to the U.S. citizen spouse, or the U.S. citizen or to the green card holder spouse, or dahil nga maraming mga nung nasuspend ang no objection statement a year ago, nag-apply na rin yung mga exceptional hardship based on having a U.S. citizen child. And we'll talk about that in a few slides after these general guidelines. The 5th ground to apply for a waiver is basically used by doctors, no? Hindi lang mga Filipino doctors, but this is actually common among the Southeast Asian doctors once they are actually working here and they are actually assigned on an impoverished state or location where there are no doctors available, then they could actually apply for a waiver. So again, their employer will be applying for that. So this is called the Conrad State 30 program. Okay, so again, pag may questions kayo dito, I will just actually read them aloud and I will try to answer them. So let's see, ZM Taros, boss, can a J1 teacher without a US citizen spouse or baby apply for an OS but willing to conduct a meritorious project? Can you provide examples of meritorious projects research? Pag-usapan natin yan, boss, as we go through the slides. The Philippines basis of waivers, no objection statement. But let's talk about the old guidelines first. Para lang maintindihan sa mga bago, no? So again, if your profession is part of the country's lists of professions or skills lists, unfortunately or fortunately, being a teacher is one of them. Whether you are teaching elementary, grade school, or high school, you are part of that list. So by default, or generally, once you are part of the skills list, you should be subject to the 212E. Ibig sabihin, after 5 years, you have to go back to your home country. But of course, there are a lot of factors na kino-consider na ang iba sa inyo is not subject to the 212E. But if the applicant is married to a US citizen or a green card holder or having a US citizen child, then in the old guidelines, tinatawag natin dito, the Philippine government EVP program will automatically grant no objection statement. Kaya napakabilis. Before the suspension, you could actually get a waiver from 1 month to 3 months. No? If you are a religious worker and in a recognized religious denomination, and I would want to talk about this kasi, again, I cannot blame the Filipino teachers who would want to explore ways of staying in the United States. And after their visa has expired or they are actually going towards the expiration of the visa, merong mga nag-o-offer sa kanila na mga religious sector to become a religious worker, no? So it could be a priest, nun, or a missionary. You have to be very, very careful with that, and I would recommend that you consult with an immigration lawyer because in any immigration case that's actually based on employment, hindi lang enough that you have a willing sponsor employer that would file a petition for you. Because number one requirement, the employer should offer a legitimate offer or job offer. And if there are really vacancies for the religious worker, then they would pass that requirement. But once after they pass that requirement, then the government will look into the qualifications of the applicant. So kung halimbawa teacher ka, tapos bigla ka ngayong mag-apply as a missionary worker, you should be able to show by certification that you actually have the formal education, training, and experience as a religious worker, maybe before you become a teacher, for you to be able to actually qualify for number 3. So, hindi yung tipong teacher ka, tapos bigla na lang, offeran ka ng religious worker, then you would actually qualify for the R visa. So, R visa kasi ang tawag doon. Number 4, they will also grant automatically before, ito yung old rules natin, if you have an ailing relative, so whether it's a descendant, ascendant, or siblings mo who are actually in the United States and you're actually living with them or you're actually providing financial support or any type of support such that na pag-uuwi ka, it will actually cause severe and direct threat to the lives of those relatives, then the Philippine government will actually provide a no objection statement for you. So again, I am still in the old guidelines for everybody's understanding. In the old guidelines also, the government, the Philippine government is saying that kung wala ka doon sa 4 na pinag-usapan natin, but during the course of your program, the applicant develop a medical condition, right? And unfortunately though, there are some applicants or J1 participants who actually had developed some serious medical conditions while they are in the program. So the Philippine government may consider providing them no objection statement. And we actually have had a lot of successful cases where we were able to obtain no objection statement based on humanitarian grounds. So dito papasok ngayon yung mga examples na yan. If the applicant is age 60 or older, the Philippine government may also consider giving them no objection statement. But of course, you have to argue your case why it will be severely or difficult for you to actually go back to your home country. or if the training or the sponsoring institution, ito hindi masyadong common ha. And then at one point in time, I actually inquired from the EVP that, hey, let's just assume that the training institution does not object to you not going home. Will they consider that? So sabi nila, it's not enough. It could just be one of the factors in making that decision, but number 3 alone is not enough. That's why they said, you have to argue your case and the Philippine government may consider. So, again, these are under the old rules. Ito yung maraming tinatanong sa inyo na, hey, nag-o-offer pa ba ang government ng alternative arrangement? So, ito yung tanong ni ZM kanina na, if I have a meritorious case of a project, pwede ba ako mapagbigyan ng no objection statement? So, for the last 3 years, even before they suspended the no objection statement applications, tinanggal na nila yung alternative arrangement. At one point in time, before May 25, 2020, ang EVP talaga nagbibigay na lang ng no objection statement for people who are actually married to a US citizen or green card holder or having a US citizen child. But outside of that, they are no longer giving NOS based on alternative arrangements. So again, if they were not able to give that before, then chances are they were actually not be giving that this time. Okay. After this, before I'll talk about the new guidelines, let me read some of your questions here. So again, pag hindi ko mabasa yung ano nyo, yung question nyo, pakisulat lang ulit. There are almost 300 live viewers here, and thank you very much for tuning in. Medyo paus ako, but just bear with me. Can a J1 teacher without a US citizen spouse, ito kay ZM to, or baby apply for a new NOS but willing to conduct? Sir, I would discuss this under the new guidelines. Sorry, I actually click on the same question. Can one comply with the home residency requirement by leaving another country, not the Philippines, after the J1 program, though they have to be physically present in the Philippines? Good question. The 2-year home residency requirement should be complied with. If you obtain your J1 visa in the Philippines, then you have to go back to the Philippines and work there and stay there, right? So hindi pwedeng pabakasyon-bakasyon ka lang kasi pupunta ka ng Canada or Australia, then you go back to the Philippines, right? So the best evidence that they would actually use to check if you really complied with the 2-year home residency requirement is they're gonna go back to your passport stamps because they will have access to that. And you as the applicant has the primary responsibility to be truthful in terms of counting the days that you've complied with the 2-year home residency requirement. So, hindi naman kailangang straight, pwedeng putol-putol, but it should be equivalent to the 2-year home residency requirement. But to answer the question, Jonathan, you have to go comply with the 2-year home residency requirement in the Philippines if you were in the Philippines when you obtained the J1 visa. But let's say you were teaching in Thailand or you'll be teaching in Indonesia, when you obtain the J1 visa, then you might want to go back to those countries at doon mo i-comply yung J1 visa 2-year home residency requirement mo. Can a J1 teacher on the 6th year still apply for the waiver unless you would qualify? Yes. Pwede, can you apply both hardship and NOS in the EVP at the same time? Yes. So, wala namang prohibition in terms of applying multiple grounds, but you have to be very careful because you can only apply for one ground. So, let's say you apply for no objection statement and it was denied, then you cannot apply for another no objection statement. Or if you already have applied for exceptional hardship and it was denied, then you cannot apply for another exceptional hardship. However, when you are actually denied either on the NOS or the exceptional hardship, then make sure that you work with a lawyer to actually either file a motion to reconsider or a motion to reopen because there is no appeal modes in terms of denial of a no objection statement or exceptional hardship. So, hindi ka pwede mag-appeal agad, right? But you might want to consider motions. Pwede po bang mag-apply ng no objection statement kahit nasa Pinas na? Thank you. So, depende po kung anong magiging basihan mo, right? Again, but these are all under the old rules. So, we'll now talk about the new guidelines. Kasi, I know that this is not something new to you, right? You've already read the published new guidelines of the EVP, I think 2-3 days ago, and you have an idea, but I think the reason why you are here now is you would want to clarify some of those guidelines. Okay? So I've actually seen in social media, particularly on Facebook, that you've been sharing all these snapshot. You could actually see it here. Yes, this is the official communication issued by the Exchange Visitor Program of the Committee of the Philippines, and these are their new guidelines now published May 24, 2021. Okay, so the good news is, and let's start with the good news, the EVP has reopened receiving applications for no objection statement exactly a year after they suspended the program on May 25th, 2020. No? So the EVP has now started receiving those no objection statement applications. And I know that marami sa inyo have prepared the documents way in advance, especially if you're married to a U.S. citizen or you actually have a U.S. citizen child and you've complied, gathered some of the documents. Unfortunately, when the new guidelines was released, there is a twist to that guidelines that the EVP will no longer issue automatically, right? So, naalala mo kanina that the old guidelines na pag halimbawa, meron kang US citizen spouse or green card holder spouse and you have a US citizen child, automatically you will receive an NOS. But under the new guidelines though, the EVP will not issue automatically. So question, can you still submit your NOS application? Yes, of course. Will you be given a no objection statement automatically? No. You have to argue your case that aside from being married to a U.S. citizen spouse or having a green card holder spouse or having a U.S. citizen child, that there are reasons of meritorious applications or cases that you could actually bring for the benefit of the Philippine government. And we'll talk about that in the next slide. Try to answer the question of ZM. Okay? So, considerations of the EVP, bakit sila nagpalabas ng new guidelines? Ang sabi nila, over the last few decades or years, the no objection statement by reason of being married to a U.S. citizen or a green card holder or by having a U.S. citizen child has become an easy means to adjust, extend, or change their immigration status in the United States. And second, they said that it has undermined the objective of the EVP because the common goal or the primary goal naman talaga ng J1 visa is to transfer skills and knowledge that you've actually gained by being or by teaching in the United States, hoping that you will go home to the Philippines and be able to share that learning to the Filipino students. No? But dahil nga, dumami daw yung applications ng NOS based on those two grounds, it has defeated the purpose of the J1 program. Magko-comment na ako dito in terms of the government's consideration. Though my opinion, this is my opinion and it doesn't really matter. I'm not the one making the regulation anyway. So, I don't think that the J1 participant will be blamed on that ground because una, sila naman ang nagbigay ng basis na if you are married to a US citizen or a green card holder or if you have a US citizen child, then we will actually give you a no objection statement waiver. So it just happened na, and I really don't think that yung mga single natin na mga J1 participants that once they actually sign in for the J1 program, that their main intention is to actually find an American spouse or a green card holder spouse or planning to have a baby just to avail of the waiver. So I don't think that is their primary objective, but they just happen to be that while they are in the United States, they met their loved ones or they actually gave birth, and then it happened to be that they will be able to apply for a waiver based on that ground. And of course, naturally, you would actually avail of that. No? So, nagkataon lang na in the last few years, yun yung nag-spike yung applicants doon. No? But we'll talk about naman on the side of the participants in the next two slides after this. But again, that was the basis of the EVP, and that's the main reason why they decided not to give an automatic no objection statement for those people who actually have U.S. citizens, children, or married to a citizen or a green card holder spouse. So, no objection statement will not be automatically be granted in the following cases. if the applicant is married to a U.S. citizen or green card holder or has a U.S. citizen child residing in the U.S. So hindi na nila automatically ibibigay yon. Again, can you apply for NOS? Yes. But you have to argue your case why the government should give you a no objection statement. If you are a religious worker, hindi na rin automatic yon. You have to argue your case. What is it for the Philippine government? So, yun yung extra challenge doon or twist doon sa old versus the new rule. If you have an ailing family member in the United States and your departure will actually cause severe and direct threat to their health and their life, then again, you might get an NOS, but it will be extra difficult for you because you have to again provide that argument. What is it for the Philippines? And if you are age 60 and above, it's no longer automatic. So again, under the 4 conditions, can you file an NOS? Yes, but you have to argue a different factor, what's in it for the Philippine government. So, sa bagong guidelines na rin, the J2 will not be able to apply for the no objection statement to the Philippine government. So, ano ba yung mga scenarios na to? So, halimbawa, may anak ka nung pumunta dito sa Amerika and then, for whatever reason, they also got married to a U.S. citizen or a green card holder spouse, or they gave birth to a U.S. citizen. So, before the old guidelines, they are actually allowed to apply for the no objection statement because the J2 is actually subjected to the same restriction as the J1. With the new guidelines now, they are no longer allowed to apply for the no objection statement. So in those cases, okay, and this is based on our experience. If you cannot apply for the no objection statement for having a U.S. citizen spouse or green card holder spouse, or if you are a J2 having a U.S. citizen spouse or a green card holder spouse, then your only option is to apply for exceptional hardship based on those grounds. But as far as the new PH guidelines on the no objection statement, they are not going to apply. They are not going to accept NOS application from a J2. The EVP will only issue no objection statement on cases under highly meritorious circumstances, and they actually give a specific example of they will be providing no objection statement to the researchers or professionals, which may include teachers whose continued stay in the United States will advance the Philippines' national interests. And it is very difficult for me to provide an example of how a teacher could actually comply with this. But based on my experience, though, we've had a lot of cases where we got green cards for our clients who actually applied for the national interest waivers, or they actually applied for the extraordinary ability based on a different category. So based on that experience, I could actually now look into how does this apply now to the teachers. So even if, kunwari, you have a U.S. citizen child and you are actually married to a green card holder and you don't want to go to the route of the exceptional hardship. So how would you be able to apply the no objection statement? As a teacher, though, and again, the goal of the J1 program is for you to actually learn something from the American culture, or maybe basically the way of teaching in the United States. If you will actually engage yourself in inventing something or improving something or in adapting a tool or methodology in teaching such that it was so great that the school or the state adopted your methodology, then this is actually an example of meritorious circumstances. Now, the recent case that I have had is actually a researcher. He was a BS Chem professor in in one of the universities in the United States, and he actually invented something that would actually be used to apply cancer treatments to a specific part of the body as opposed to having apply it for general treatment. So if you are actually a teacher, let's say in a SPED category, if you could actually adapt, create, develop some approaches of actually improving the way of teaching special children, or if actually a way of improving teaching math or science, then it could be a meritorious circumstance. But it's not enough for you to invent those methodologies. You have to actually be the leader in terms of the implementation. So let's say your school has implemented a program, right? It could be in physical education, it could be in chemistry, it could be in math. And because you are considered an expert in your school, that you want to be part of that program and you enroll yourself as a member. It's not enough to be a member. You have to be on the leadership role. You have to be a team lead. You have to be the lead researcher. Because then again, it only shows how challenging US immigration is. They don't care about the ordinary worker. They actually want the extraordinary worker, the extraordinary employee. At the end of the day, this is US immigration, right? So again, the Philippine EVP is just trying to protect the program on the J1 EVP. And as much as they would want to offer the no objection statement for people who actually are married to American citizens or green card holders or having US citizen child, I think that approach has undermined nga yung purpose ng J1. So, then again, it's not, I agree with you, it's not a total good news for the teachers that the EVP has added an extra criteria in providing no objection statement. But at the end of the day, you are already here in the United States, you are married to a US citizen. Again, for people who are married to a US citizen or a green card holder or having a US citizen child, you have another option potentially of filing exceptional hardship. But if you don't have any no objection statement grounds, or if you are only looking into the having a US citizen child and you plan to apply for the no objection statement, then it will be exceptionally hard for you because of that additional guidelines. Okay? So, if you would want to actually go into detail, what are examples? Pasensya na guys, this is New York, right? So, this is common scenario for us to have sirens all over the place. So, if you would want to actually have a specific detailed conversation of what meritorious examples you could actually do in your school, I would recommend that you actually consult an immigration lawyer to actually guide you. Because then again, the new EVP guidelines is saying, yes, we are going still to accept your no objection statement. Are we going to automatically issue NOS? No. Unless you would be able to prove to us that your case fall into any of the meritorious cases that actually that would oblige them to issue you a no objection statement. Okay? So, magbasa tayo dito, no? Naging passionate lang ako dun sa conversation na yun. From Maria, magandang gabi po, attorney. Once we go home, we will teach automatically be hard in the Philippines. Simply po, as you said, to share what we got here. Okay, so ma'am, I'm not representing the Philippine government, right? And I fully understand where you are coming from. Especially with the pandemic, there are no available employment for you, that you are not actually guaranteed that once you resign from your school before you enter into the to the J1 program, that there's no guarantee that you will be hired back. But you are in the situation where you are, right? So I know the difficulty, I know the challenges going back home without employment, but I'm not the government, right? So I'm just sharing what the EVP is coming, or where the EVP is coming from, okay? Miss Anne, hello attorney, my J2 child went home 2 years ago when he turned 21. How will he okay, so ma'am, yung J2 mo na nag-comply na ng 2 years, there is actually no extra action from their end. If they would want to go back to the United States to apply for another J1 or H1 or immigrant visa, they don't have to show something, but I mean, they don't have to do anything, apply something, walang ganon. Titingnan lang nila yung passport stamp mo, and if you could actually show that you've been out of the United States for 2 years or more, then you already complied with the 2-year home residency requirement. So that's what it meant. Okay, what about if the Philippines ask us to resign before coming here? Okay, so Ma'am Che, can you actually write a follow-up question? I'm not so sure if the Philippines asked you to resign after your J1 visa issuance, or was it before you were issued a visa? Okay, para lang ma-answer natin yung tanong mo, ma'am. Ma'am Gladys, with regards to that question, attorney, yes, OFWs are given priority in the deep end. Okay, so then that's good news then, right? So again, I would recommend that you would actually call the EVP, coordinate with the EVP ko. Mayroon naman silang balik-turo program on how you can be reintegrated to the Philippines workforce again. Gladys, although J1 teachers are maybe not considered as OFW, still pag galing ka abroad, nagtatrabaho, you will be given priority as depends. So again, that's good news. And again, I fully, again, don't think that I am insensitive or I'm not aware of your sentiments, right? I understand. Ang dami ng teachers kong nakausap. I know where you're coming from. I know your concerns. I know your intentions. But at the end of the day, these are regulations, right? And it's, you have, ang ilang beses na nagbigyan kayo ng opportunity to reach out to the Philippine government agencies or officials. And at the end of the day, it's a committee that decides on these regulations, right? Hindi lang CFO, hindi lang Department of Education, but it's a committee, no? So they actually decide this collectively. Mayflower. What if I am not married to a US citizen and no US child? Can I try my luck on meritorious circumstances for NOS? So then again, if your case fall into a research or a project that is being implemented in your school and that your participation would actually compromise the progress of that case, then you may fall into the meritorious cases. So if you actually read on the EVP guidelines, they actually give in particular the research work. We call it the work product of any profession. So it could be a work of a researcher, it could be a work of an IT consultant, an IT professional, or anything. But the rationale of it though is, so let's say you are a chemist, you invented something, and then the government, the US government is interested in pursuing that idea. And because J1 program ka, you need to go home, then you have two options there. Either that particular government agency in the US will be interested in filing a waiver on your behalf because they understand that if you go home, it will be compromising the success of that project, or on your own, based on the no objection statement, because you are a team leader or you are a project manager of that particular project, that you would apply for the no objection statement. Why will the Philippines be interested in those projects though? Because pag kunwari, i-grant ka nila na bibigyan ka ng objection statement, part of that requirement is for you to actually train group of beneficiaries in the Philippines of at least 20 participants to fully understand on a project that you are engaged in. Yun yung intention nila, na hindi pa rin nawawala yung purpose ng J1, because part of this meritorious circumstances requirement is for you to go back home to the Philippines and at least spend 40 hours, I believe, of training work of at least 20 beneficiaries for you to be able to share your project, or in this case, meritorious circumstances, no? Yun yung intention nila. Okay? One thing that I could actually think of is, halimbawa, math teacher ka, that you've actually developed on how to effectively teach math. And again, but hindi enough maging member lang. You have to be a team leader. You have to be an implementer. You have to be considered a significant player in that project for them to actually consider you as significant contributor. So, wag kang mag-settle into being a member lang. So again, if you would want to discuss detailed examples of meritorious cases or projects, I would recommend that you set up a consultation with an immigration lawyer so they can guide you. Okay? So, ito yung twist natin, no? Na hindi lang enough na magkaroon ka ng anak ngayon. And I know it's very challenging to have a child in the United States because now the government is requiring to go beyond what is required of you, because you have to have these projects or ideas or tools that you need to implement or be part of in your school to be able to be granted no objection statement. If you could not get a no objection statement and you actually been part of these projects, there is also another avenue that you could apply, the extraordinary ability. But I don't want to complicate my conversation now. I'm just going to focus on the no objection statement conversation. Kasyan, would J1 teacher marrying military personnel have influence in the J1 teacher obtaining the green card? So, in your case, Sian, your best approach is to apply for exceptional hardship. Military members cannot easily just leave the United States and go with you to comply with the 2-year home residence requirement. We have a lot of cases for military members, and you actually had a very, very good chance of being approved of exceptional hardship waiver. Karen, question though, if you are exceptional teacher here in the United States and part of the team, lead team, and use that case to apply for the NOS, how is it beneficial to the Philippines? Very good question, ma'am. It's actually for you to answer though, right? So halimbawa, you are an agriculture teacher and you've invented something or you learned something from the way of planting whatever, corn, let's say, no? And this project could actually take 5 years to complete, and you are a team lead, you are a significant contributor. The Philippine government will again allow you to be given a no objection statement because part of that NOS is for you to train 20 beneficiaries in the Philippines of whatever learning you have by being a participant of that project. And you have to go home for 40 hours training for at least 20 beneficiaries. So, doon pumapasok yung Philippine national interests. The only complication there is if you are involved in that high impact projects, kung walang confidentiality agreement, then it's okay for you to share. Pero pag may confidentiality agreement among the members that, hey, you cannot share this outside of the group because they are still in the developing part, and then that's an extra challenge for you. But to answer your question, kung how is it beneficial to the Philippines? Because indeed, the Philippines will actually benefit from it. Kasi nga, tuturuan mo yung 20 beneficiaries, ma'am, whatever your project is. And it becomes of national interest. I mean, improving the way we grow corn, in the case of agriculture, or improving the way you teach math, because you invented a tool. Of course, you have to go back to the Philippines and teach 20 math teachers. So that's how the Philippines national interest is actually being implemented. So in that particular case, as based on the EVP guidelines, they will consult the appropriate government agency. In this case, the Department of Education, that, hey, may proposal tayo dito, how do you look into this one? This is actually similar to before when we actually filed no objection statement on the basis of having you develop an illness while you are in the program. We have to provide them extensive medical records because those evidences of medical prognosis, diagnosis, or treatment will be forwarded to the Department of Health. And it's the Department of Health who will make a recommendation that indeed your case is meritorious. So in the case na example na sinabi ko, right, yung pag-improve na pagtatanim natin ng corn, then your proposal will be forwarded to the Department of Agriculture, and it's up for them to actually recommend kung ang case mo talaga is meritorious. Because again, that's the way on how they will identify if your project is meritorious and would benefit the interest of the Philippine government. I hope I was able to answer that question. I think DepEd will no longer hire teachers who is already in their 50s. I believe work opportunities will be applicable to younger teachers. Yeah, ma'am, I understand that. But then again, they allowed that under the old regulations. So we don't know what has transpired in the discussion of the EVP committee when they actually decided that, hey, we are not going to provide or accept or approve no objection statement for people who are 60 or older. I fully understand where you're coming from, right? I cannot imagine me being 60 years old and still go back to the Philippines and work, right? But then again, for teachers who are already in the United States, you have that opportunity to be part of any significant project in your school. I know it is very hard, but if you are interested in getting a waiver, then your only option is to comply with the Philippine government's requirements. Unless, again, you are married to a U.S. citizen or green card holder, where you have another option of getting a waiver. In this case, the exceptional hardship. Okay, I hope you are not asking the question as if ako yung magde-decide ng waiver nyo. I'm just actually sharing what the EVP's guidelines meant by actually just giving you examples. So you could redirect your priorities or you could start working on it so that by the time comes that you need to apply for the no objection statement, you actually have a better placement or you are in a better place to winning or getting your no objection statement. From Richard, halimbawa ang isang teacher po ay isang research leader ng school at ang research project is successful, ano ba yung mga supporting documents to prepare in applying for the NOS? Sir, pag-usapan natin in the next slide, ano yung bang ibig sabihin ng meritorious research and studies? Okay, that's a good question then. So una, sinasabi nila, it has to be sustainable. Now, so I actually have, again, yung example ko na we were able to apply for a green card on his own kasi naka-invent siya ng way of applying or treating cancer. It has to be sustainable. Hindi pwedeng paperwork lang. It has to have a practical application in the industry. Hindi naman kailangang may evidence ka of success treatment, but at least there is a probability that it can be applied in a more practical sense in any industry. Yun yung sinasabi nila na sustainable. And how would the EVP know that if it is sustainable? In the case ng example natin ng pagtatanim ng corn, then you have to consult the Department of Agriculture whether or not your project is sustainable. Part number 2, is it suitable for the current priorities of the Philippine government, right? So I think agriculture or teaching is still a priority in the Philippines. So I would not be surprised that if you have a very meritorious project that you're involved in, then try to submit that because, again, education is still part of a priority aspect of the Philippine government. Agriculture is one. Maybe anybody who is involved in biology that actually talks about COVID is a priority of the government. But then again, you could send an email to the EVP. You could ask them, hey, what are the priority industries or projects that you would be involved, you would be interested in, so you could realign your activities now. Then I would encourage you to do that. And number 3 will improve the quality of research and development in the Philippines. Because then again, right, pabalik-balik na lang ako dito. Part ng requirement of you getting a no objection statement is that you will go back to the Philippines, provide 40 hours of training to at least 20 beneficiaries before ka makakakuha ng no objection statement. So, yun yung paraan ng Philippine government that hindi ka na ngayon magstay sa Philippines ng 2 years because yung skills na natutunan mo or na learn mo in the United States will still be able to benefit the Philippine government through that 20 beneficiaries that we initially talked about. Okay. Alicia, by the time I will be given 2-year extension, I will be 62 years old. By then, is there a chance that I will be given an OS? So, ma'am, sinabi nga nila, hindi automatic, no? But you could still apply. But it's not enough by saying, kasi dati, pag nag-apply ka ng no objection statement, birth certificate mo lang, ma'am, and of course, other requirements, bibigyan ka na ng no objection statement, ma'am, no? But now, they said it's not enough. Right? Again, is that, do I approve that as a requirement that you have to be involved in? Not necessarily, though. But reading the new regulation, that's what they want, no? So maybe argue your case once you apply for the no objection statement to the EVP. And hey, I am 60 years old. I will not be able to find work in the Philippines. But I'm willing to teach. So again, argue your case. Ito lang yung pinagsasabi natin. Ruru, can a teacher with a J1 visa be enrolled in a graduate program in the US? While you are on a J1, yes, you could actually engage yourself into further studies. But after your J1 program, no. Hahanapan ka ng waiver once you apply for a change of status from J1 to student visa. Sian, if a baby born in the US with Filipino mother and American father still be considered a US citizen? Yes, if the child is born in the US, automatically they are considered US citizens. But if you are outside the Philippines, you might apply for consular birth abroad, CRBA. Okay, so pasensya na lahat kung hindi ko mababasa lahat kasi marami-rami din ang nag-question. Let's just go home and do our part. We already gained much. That's good suggestion, Sharon, and I will actually share some of the slides talking about those. So, again, before ako sa now what, no? Isa-isahin ko lang muna dito, baka mayroon pa akong masagot na tanong. What about if, from Diane, what about if I train teachers in the US about something I know in technology through our professional development? Does that count as meritorious research? So again, ma'am, without the specific of what we're talking about, it's very difficult for me, right? But then again, malalaman mo naman kung meritorious yun, ma'am, eh, no? Once you implement something, the the leadership of the school will be very much impressed about that initiative. Then they would start talking about that. Then the other schools hears about it. Then maybe you would apply for a competition if there is such a thing in the education industry, or you might want to apply for nominations of best projects in the whole state. Then that's how you actually start building your case that this project is meritorious. Okay, and we've seen some of you. It's not for everybody, but there are some teachers who actually go into that route. They are actually planning to apply for the O1 visa, the extraordinary ability. Again, O1 is not for everybody. It's only for those who actually presented meritorious projects. Hi, Chad. Just want to say hi. Okay, hi, boss. Salamat ka, green card holder ka na, boss. L, what about benchmarking programs and sending proposal for implementation? So then again, ma'am, benchmarking. I am an industrial engineer and we do a lot of benchmarking, right? So benchmarking is basically copying a very good project and implementing it to a selected area of application, right? So then again, if you're just copying a project that is being implemented in the school, and then I think what you're trying to say is you want to present that to the Philippine government and say, hey, I have this project, can I actually select a group of beneficiaries and just teach them? So again, do not forget that the research and studies alone is hindi niya sinasabi na ito yung pinalit nila doon sa old rule nila na alternative arrangement no? Kasi ang sabi nga nila na hindi na kami magbibigay ng automatic no objection statement sa mga nanganak lang or nag-asawa lang or 60 years old ka na or nagkasakit ka and so on and so forth. But they are now opening themselves to say, if you fall into those 4, fine, but we need some extra reason why we should give you no objection statement. However, paano kung wala ka dun sa 4, but I have a very good project? I think that they are opening that particular route now. Na hindi ka kailangang magkaroon ng anak, hindi mo kailangang magkaroon ng green card holder spouse or US citizen child, right? That you don't need to be 60 years old. You don't need to be, ganyan. Ito yung sinasabi niya. If you have a project, if you're engaged in an initiative sa school mo that merits granting you a no objection statement, then pursue that. No? Ang sinasabi lang ng regulation, hindi na enough yung grounds na 4 lang. Kailangan mong gumawa ng extra step for you to convince us that your case is meritorious. Yun lang. Mahirap ba yun? Yes, I would say. Kasi, dati, mabilis nga. No? It's the easiest way. May anak ka, may asawa ka, then you will be given a waiver. Marielle, attorney, what would you recommend then for a J1 teacher who gave birth here in the US and has 2 J2 husband? So, I think you said the J2, 1 husband and a child, I would say. She'll try to NOS, just apply for exceptional hardship. Ma'am, recommendation ko, ma'am, if you are basing it on US citizen child, then explore the exceptional hardship on the child. Though hindi lahat, ma'am, nabibigyan ng waiver based on exceptional hardship on having a US citizen child, though you still have to argue your case. We've had a number of cases like that, but hindi lahat ng may US citizen child tinatanggap ko kasi nga mahirap i-argue. But again, I'm not going to make a conclusion now. What I would recommend is that you consult an immigration lawyer if you would be able to win an exceptional hardship based on having a US citizen child. Are you going to apply for NOS only based on that ground? Try, no? But then again, be prepared if the Philippine EVP will ask you about saan na yung meritorious cases mo. What would it be for the Philippines to give you a no objection statement kung basihan mo lang is having a US citizen child? So, again, just be prepared to answer that particular question. Princess, highly microscopic does not necessarily mean on a state level, right? Hindi naman natin sinasabi. Ang sinasabi lang natin is you are in a better way of gauging whether the project you are actually having or leading is meritorious kasi naging popular siya or naging bulong-bulungan siya dahil nga effective yung implementation. Does that make sense? So I'll give you an example. I always go back to that example of the client we have who actually invented a way of applying cancer. Because that particular project, popularity is by the way not a requirement, right? But kung effective kasi yung project mo or initiative mo, you cannot help but become popular eh. Right? In that particular case, doon sa chemist, sa sobrang effective nung ginagawa niya, he actually made a write-up on that. Then, because of how effective it is, he was invited to speak in conferences. He was even invited to go to Germany to be part of the Nobel Peace Prize winners dahil nga sa ganda ng ginawa niya. Right? He was nominated in the school. He was nominated in a competition in a state level. But to answer your question, yes, it's not required to be in the state level. It could be in the district level. Right? And then, pag present mo ngayon sa Philippine Department of Education and they were impressed by that, but you cannot go home to the Philippines because leaving your program will compromise the success of the project, then you might be given a no objection statement. I hope I was able to answer that question. It could be either adopted or used in a school or district or become considered a meritorious one. Again, I would recommend, ma'am, that you discuss with an immigration lawyer with specifics so that the lawyer will be able to guide you. And I will not also stop you from talking or communicating directly with the EVP, no? Na before you would even submit the no objection statement, get guidance from them that, hey, ma'am, I have this project, I'm involved in this. Will this be at least merit your analysis or initial review before I would invest time and money to be part of this team or to be part of this project. So I would encourage you to actually communicate with the EVP then. April, this could be an option for those teachers who are not eligible for a waiver in the Philippines via NOS or hardship. I'm not so sure if what you are saying, ma'am, but I think what you meant is it could be an option for people who have no children or you are not married. Yes, they are actually opening that route. Kasi kung titingnan mo yung EVP guidelines nila, they actually made in particular as an example yung researchers, right? They didn't actually say that you have to have a child first or you have to have Meritorious before you could apply for or present a project. So, nagiging mas higher lang yung standard nila pagbibigay ng no objection statement. Sino po kaya makapagbigay sa amin ng detailed criteria para doon sa research na nabanggit? Ma'am, I would recommend that you send an email to the EVP. I think the EVP is willing naman to share that with you. Or, on the alternative, you could actually consult an immigration attorney. Kasi nga, ma'am, meritorious cases, it has to be discussed in a case-to-case basis. Even in our cases na nag-a-apply ng extraordinary ability or national interest waivers, we need to have series of meetings first before we could even decide whether this will pass a national interest waiver or whether this will actually pass an exceptional hardship waiver. It's not as easy as i-present ko yung application mo, hey, will this pass meritorious cases? It has to be analyzed. It has to be reviewed kung based on this criteria nga, di ba? Is it sustainable? Is it suitable because it actually supports the Philippine priorities? Or will it improve the quality of research and development in the Philippines? So, again, it's not as easy as that. I would recommend two things. You could either directly contact the EVP or consult a lawyer and discuss the details of your project that you're in. Dial, in connection to the question, can this be used as meritorious work, the writing of thesis? No, sir. The writing of a thesis or a dissertation is not enough. Ito yung sinasabi natin na sustainable, right? Hinahanapan pa rin ng practical application yung project mo. So, hindi lang siya theory. Dapat sustainable siya. Clara, should we create or invent or tools? Can we share what we have learned here? Can we just share? So, again, when I actually say create or invent tools, it does not apply to all subject areas kasi ng teaching, right? But if you are actually in the chemistry or in the science area, it's possible for you to create or invent tools. If you are teaching math, it might be possible for you to adapt a strategy to teach math, right? And we've seen that in YouTube that they actually have a way of teaching math. Or if you are in the area of biology, maybe you would invent something, right? So yun. But is it the primary requirement? No. But then again, if you would want to present subject or for meritorious considerations, you could contact the EVP and ask their initial opinion. April, based on my experience, if you work in other countries before you come to the US as J1, you can try to get a waiver from that country and not from the Philippines. Sir, that is a wrong information though. The chargeability of your application is based not on your, if you are coming from Thailand, you are not as a citizen of Thailand. It's actually just saying last country of residence. It only means that you have the two options of complying with your 2-year home residency requirement, whether you go back to the Philippines because that's your home country, or you go back to your last country of residence, in that particular example, Thailand. But the the Thai government will not give you no objection statement because you are not a Thai citizen. So I would just want to correct you on that. Ruby, if in case we got denied on the no objection statement, do we still have an option to apply for? Yes, because again, the denial of one ground does not prevent you from applying another ground. Ang prohibition lang is using the same ground. So kung nag-apply ka na ng no objection statement based on having a US citizen child at na-deny yun, then you cannot apply for no objection statement, but you might apply for exceptional hardship. Pwede yan. Okay, so last na lang to kay Bell, then I will proceed on. What if the CFO would ask a copy of my waiver granting I get the opportunity to waive the 2-year home residency requirement to stay in the US? Department of State due to marriage to a US citizen. Okay, antindihin ko lang yung question na, what if the CFO would ask a copy of my waiver granting I get the opportunity to waive the 2-year home residency requirement in the US Department of State due to marriage? Okay, so yung sistema kasi, Bell, ganito yon, no? So let's just assume that you would be able to apply for the no objection statement based on being married to a US citizen. Ang mangyayari doon, i-apply mo yung NOS mo sa Philippine EVP. The EVP will grant your NOS, if-forward nila yun ngayon sa Philippine Embassy in Washington, D.C. So, may section doon na in charge on waiver applications. Once they actually receive that, they will forward it to the review division of the Department of State. So, pag nakuha ng Department of State yon, they will actually make a recommendation that you will be granted a waiver based on the recommendation of the Philippine government. In this case, the no objection statement. If forward niya ngayon yon sa USCIS, and then USCIS will give you an approval based on the no objection statement. So, to answer your question, no, the Philippine government will not ask a copy of your approval notice, but the Department of State, USCIS, through the Department of State, will require a copy of your approval recommendation of no objection statement from the Philippine government, so they could actually issue you an approval, a waiver approval of the 2-year home residency requirement. So it should be the other way around. April, I was saying that other option for German teachers who work in other country before coming to the US. Okay, so Ma'am Abril, no, I would recommend that you actually consult a lawyer, because the way I understand your question is, let's just use as an example that, hey, you're a Filipino, you are actually working in Thailand when you actually get a J1 visa. When you actually said that, hey, can I apply for a J1 in Thailand? Ma'am, you are going to submit your EVP application on no objection statement, not in Thailand, but you are going to send it to the EVP in the Philippines. Right? Wala namang EVP Thailand na makikita ng Filipino nationals, right? So, the recommendation will still come from the EVP Philippines because you are a national of the Philippines. So, ngayon, pag in-approve nila yon, then i-forward nila ngayon yon sa Philippine Embassy in Washington, D.C., and then i-forward yon sa Waiver Division. But as far as complying that one, then of course, you can go back to Thailand to comply. But getting that, I am not so familiar. I don't know where you come from, get that idea, but not based on my experience though, no. Patricia, so what will happen if you are meritorious citizen, have a US child, but are not able to do meritorious achievements? So, ito yung sinasabi nila, ma'am, that the EVP will not give you automatic no objection statement. Sad, hard, yes. But that's what their EVP new guidelines sounds like. If I got, if J1 got the exceptional hardship, what will happen to J2? Ma'am, pag kunwari nag-grant ka na ng exceptional hardship, yes, the J2 will automatically be given the waiver. So even those na nag-21 na, and they were able to maintain status in the US, they could still use that waiver to actually pursue whatever they want to do after the J1 has been approved. The J1, the waiver approval will actually say that any J2 part of that application will benefit from the waiver. Aiden, I've applied for exceptional hardship for my U.S. citizen child June 20 and I asked to submit additional evidence by, and now my case is on hold since February 2021 saying they have requested another non-U.S. advisory opinion for my case. What are your thoughts about the status? Okay, so ma'am, I can only comment on the procedural aspect of it, right? So kung kunwari, nag-apply ka ng exceptional hardship based on having a U.S. citizen child, they actually forward it to the pertinent government agency. So example, if part ng argument mo doon sa exceptional hardship on having a U.S. citizen child is because there is a medical condition component of your argument, then they would actually consult the Department of Education, oh, hey, what do you think about this? Or if you're actually looking into the benefits that the child may not be able to avail of if uwi siya ng Philippines, then maybe they could consult the Social Security, the Social Services Department. So, yun yung ibig sabihin niya na on hold because they are actually getting the non-USCIS advisory opinion. And that's very common for applications like that. Am I in the position now to say you will be approved or you will not be approved? No, because again, it depends on your arguments. But the way that you are saying your normal yon in terms of procedure. So, naka-on hold lang siya kasi hinihintay lang nila yung recommendation ng particular government agency being affected by your arguments. Rodi. Okay, Rolly, can you just retype your question because daming questions, boss, hindi ko mababasa lahat. What if the J2 will be offered by his employer a regular job? Can he apply for the H1B? So if your J2 is subject to the 212E, then before he will be able to apply for H1B or immigrant visa, they have to comply with the 2-year home residency requirement. Rolly. Sian, with my soon-be wife being Filipino and visa expiring soon, if she has to go home for 2 years, what happens after those 2 years? Does she get her green card then or can she come back here? Sir Sian, again, I think you have a very good chance of getting exceptional hardship waiver. The exceptional hardship waiver is applied through the department, through USCIS, and of course, they will get the opinion of the Department of State. But then again, don't worry about her going home because there's a big possibility that you might be approved of an exceptional hardship. But to answer your question, if she decides to go home after 2 years, if you file a spouse visa, then she can come back to the US on a green card. Ron, are J1 teachers allowed to join the US military? Not as of the moment. I mean, the primary requirement of, okay, let me step back. Yung military ability to apply to join the US forces has changed several times over the years. At one point in time, they would actually allow being a student visa holder, F1, to apply to join the military. At that time, there was war in Afghanistan or in the Gulf course, right? But then the world has been quiet for a while. As of the moment, they are actually requiring you to become a green card holder at least to apply to join the military. I haven't seen a new regulation saying if a J to be able to apply for the military. The best way to do is call them and check if they would actually allow J1 or J2 to join the military. But as of the last time I've checked, they will require green card holders to be able to apply. Or you are a US citizen. Fritz, what if during the J1 teacher program she gets pregnant? Anong mangyari? Pauwi ba siya ng J1 teacher at family niya? I think you're referring to a contract between the J1 participant and the J1 sponsor. I've seen some contracts where it says if you get pregnant, then you have to go home because they are going to cancel your J1 visa. So you have to understand where the J1 sponsor is coming from, though. So ang sinasabi lang nila, if you become a J1, I mean, if you become pregnant while you are in a program, then there is a more likelihood that it might affect your performance being a teacher because siguro problematic yung pregnancy and so on. But for as long as it does not affect your performance, I don't think the J1 sponsor would really enforce that contract. Though the provision of the contract is there, if the J1 sponsor would want to pursue that against you because you breach the requirement of the contract, they can. Did I see that happening? No, not really, right? Because again, for as long as your performance is not being affected by you being pregnant, I don't think they were going to pursue that. So to answer your question, hindi naman, wala pa akong nakikita o narinig na J1 applicant na nagbuntis na pinauwi ng J1 sponsor for as long as hindi naapektuhan yung trabaho niya. Rafi, is it possible to apply K3 visa if my NOS gets denied? Is that an option? K3 visa is basically available to spouses of a U.S. citizen who are currently outside the United States. It actually gives the applicant the ability to come to the United States earlier pending the application of the spouse visa. But it's a discretionary application. Ibig sabihin, you still have to apply for that. But if you are already in the United States and you are on a J1, then applying for a K3 doesn't make sense. Okay? But then again, if you are married to a U.S. citizen, apply for exceptional hardship. Then apply for your green card. Rolly, may specific timeline po ba ang length ng research projects para? I don't think so, boss. And I'm actually looking into this using my hat as an industrial engineer. Depending on the project that you have, so it really depends kung kailan matapos yung timeline ng project mo. So again, it depends on the complexity of the project that you are actually being involved in. So what the EVP is looking at is sustainability, right? Na pag nakita nila na may practical application to, or it is actually supporting the priorities of the Philippine government, and that you have the ability to actually impart those knowledge to at least beneficiaries in the Philippines, then they might actually approve your meritorious case or project. Christine, my friend is divorcing in the US. However, she was not in the Philippines. She may use citizen. Exceptional hardship, ma'am. They are not eligible for NOS. Patricia, after fulfilling the 2 years in the Philippines, can you directly re-enter the US with H-1B? Yes, after you complied with the 2-year home residency requirement. Ruby, nagbago din po ba yung timeline for approval ng NOS under the new guidelines? This is how I actually look at that, right? So the no objection statement has been suspended for over a year. So at least a little bit over a year. So you can just imagine people who already filed their application or prepared the application, and once the EVP actually says that, hey, we are now going to accept NOS. So kung gaano karami yan. The problem now is, how long does it take for the EVP committee to review your application now that they added a component that hindi lang enough na mayroon kang anak, may asawa. So I would say that it has affected, but before you could get NOS recommendation from 1 to 3 months. Mariel, let's say I will decide on applying exceptional hardship this June with the help of immigration lawyer. How long it takes? 7 to 9 months, ma'am. And then after that, you would probably be able to apply for the green card. Jonathan, do we have an estimate how long it will take to get an NOS decision on the EVP? I think I answered that question. Okay, so maraming questions talaga. So I will just proceed with the next slides then. So what now? Okay. And again, guys, I apologize if what you would hear from me is not favorable to you. But I have to say my piece, okay? What now? For people who are outside the Philippines applying for a J1 visa, manage your expectations. Because when you sign up for a J1 visa, you know very well that your visa will expire 5 years later. And I think the Philippine government, or I hope the Philippine government was able to communicate that clearly, that once you apply for a J1 visa, that visa is not a work visa. It is an exchange program, and you commit yourself to going back to the Philippines 5 years later to impart your knowledge and education so that the Philippine government will benefit from it. So, but of course, once you are already here, you would want to stay here for whatever reasons. I understand that. But the Philippine government is now giving extra difficulty for you to get a waiver. Without a waiver, there is no way for you to apply for H-1B or offer an immigrant visa. Especially now that they are saying that it's not enough to have a U.S. citizen spouse, a green card holder spouse, or having a U.S. citizen child. So I really hope that if you sign up that paper for a J1, that you already have accepted the reality that there is a big probability that you will go back 5 years later. Okay. Ngayon, yung mga nandito na sa US, of course, no, I would presume that you have that same information when you sign up the J1. And again, fully understand where you're coming from, that you would want to stay here in whatever means. It is just unfortunate that after the pandemic, the EVP has suspended the NOS, because lucky are those who already filed the NOS before they suspended it on May 25. Now, a year later, they opened the NOS application. Unfortunately, they require now more extra requirement for you to get an objection statement. Lucky for those, again, who are married to a U.S. citizen or a green card holder, if they cannot get a no objection statement, they could probably apply for exceptional hardship. Or if you have a U.S. citizen child, then you might be able to have a no objections, a waiver based on exceptional hardship, based on having a U.S. citizen child. Now, for those who are not having a U.S. spouse, a U.S. citizen spouse, green holder spouse, or a child, the new guidelines actually gives you another option if you can only present meritorious cases or projects or research work. That's how I would say on managing expectation, right? Because if you are just going to use your emotions to argue with this, you will never win. Okay? Most importantly, if you want guidance, seek an immigration lawyer so they could actually guide you. When I actually give advices to some of the group of teachers or individually, I tell them that when you are already in your 5th year or on your 6th year or your 7th year, and you have no ground, then accept the reality that you will go back to the Philippines, stay there for 2 years, and then, but prepare for your next step, which will basically will be on my next slide. Number 2, go beyond what is required from your job, right? I've been an industrial engineer. I've been an associate professor. It's possible for you to go beyond a mile. Take a mile ahead of what you are doing, because again, this is U.S. immigration. It's not easy to get a visa. So if the regulation from the Philippine government requires you to do that extra project or be part of a team that do research, then do that. If your goal is to apply or get your green card or apply for an H-1B, because then again, these are rules, right? I've seen a lot of school who actually contacted their senators and congressmen hoping that they would be able to get no objection statement from their teachers who are well performing in their school. But at the end of the day, the congressman has no power to override rules. These are government rules issued either by the Philippine government or the U.S. government. Your job is to comply with the requirements. Okay? Third, decide wisely. If you are already in the if you are outside the United States now, and you are actually given offered a teaching job in the U.S., ask your potential employer or your agency, am I getting a J1 or an H1? If you decide to accept the J1 offer, then again, we go back to number 1, right? Manage expectation. You have to accept that you are most likely be going home 5 years later if you cannot apply for a waiver. But if you are given the option to getting a J or an H, then choose H, because there is no restriction for you to go back home to your home country 5 years later or 6 years later. I actually just have had a consultation yesterday where that particular teacher is actually having a very good job in the Philippines. And of course, the school is very interested of hiring her. But she did not demand. She actually just said that, hey, I have a good job here in the Philippines. If you are going to offer me a J, I'm not going to accept it. But if you are going to give me an H, yes, of course, I will be flying tomorrow if the visa is available tomorrow. So I hope don't jump into, don't be too excited enough and grab any opportunity that is offered to you coming to the United States if you are not prepared 5 years later that there is a possibility for you to go home. Okay? So, yung mga nandito na sa US and you happen to be not subject to the 212E, there are two options for you. Either you're gonna ask for an advisory opinion before you will apply for the 2-year extension, so that if true enough you are not subject to the 212E, then the H1 or immigrant visa is available for you. Okay? Pero kung kunwari talagang hindi ka makakuha ng waiver, then again, there are decisions you need to make. No? Because you don't want to be out of status in America either. So decide wisely on your options. And don't listen too much from your friends or from your coworkers as far as what's best for you immigration-wise. Consult an expert, in this case, an immigration lawyer, to decide or help you decide what's best option for you. Number 4, maximize your opportunities while in the United States. So let's just assume that you already have accepted the fact that you will never be able to get your no objection statement, and you are already coming towards your 5th year or 6th year or 7th year. Then, wala ka nang magawa dun eh. Right? So, ang recommendation ko is maximize your stay while you are still in the United States. Connect with your potential H-1B employer. And we've actually worked with a number of school districts, and we've convinced them that, hey, no matter how much you love your Filipino teacher, that teacher will go home in June. Kasi nga, hindi na ma-extend yung J1 visa nila. But if you really would want to help them out, then start the green card application now. If they're gonna comply with the 2-year home residency requirement back in the Philippines, if you're gonna start your immigrant visa journey now, then chances are 2 years later, they are already in their way, waiting for their embassy interview in Manila. So again, establish your connection while you are still here. Influence or convince your employers to start the filing of your green card application. Itong scenario na to, pag talagang hindi kayo makakakuha ng waiver, right? And then, financially prepare for your next step. So I understand people, when you enter into that J1 program, you only have maximum of 5 years. So again, unless you will get a waiver, in the case of people who have had 6th year extension or 7th year extension, it's due because of the pandemic. But while you are still in the United States, prepare financially. So I would just like to clarify this. There are visa types which require employers to pay the filing fees and the processing fees, in particular the H1. So in the H1 visa, employers are required to pay all the fees associated to bringing you to the US on an H1. But that obligation doesn't cover your spouse or your children. Responsibilidad mo na yun. Pero in a green card application, even in those cases where the employer would say, oh, we are willing to pay for your visa processing and so on, it still is expensive to buy your tickets, to relocate in the United States, to buy your car because you happen to be not in New York or in Chicago or in California, right? Because majority of the places in the US require you to drive. It is expensive to work and live in America. So if I were you, save now while you are still having the work in the United States, and you all do this because you cannot obtain your visa. So I hope that is on the practical side, the way I see it and where you are at now. So again, it's unfortunate that the EVP has already provided extra requirement for you to get a no objection statement, but that's the requirement. Again, as an applicant, your goal is, or your responsibility is to comply with those. Okay, and I hope that this presentation is able to give you guidance as to, okay, what do we do now, knowing that there are new guidelines from the EVP. Okay, so that's basically my piece. I would want to very quickly go over the following slides, assuming that you actually have a no objection statement waiver or you already have complied with the requirements. Babalikan ko yung mga additional questions after the fixed new slides. But again, you can review my presentation in a bit after this, but think about the two slides that I actually just mentioned after the what now. Okay, because that would help you at least manage your expectation moving forward. So again, if you already have or you are planning to apply for the NOS, when is the best time to file for NOS? If you are married to a US citizen, at least 1 year before your J1 or your third year expires, or after your 2-year extension has been approved. If you were offered an alternative arrangement, so again, the same timeline applies. So apply for alternative arrangement if you believe that you have a meritorious project or case or initiative that you are having, maybe after your 2 years, because the NOS requires you to comply 2/3 of your program, or after the approval of your 2-year extension. Filing for H1B, and again, we've held a number of schools schools, districts. We've converted them from cap to non-cap to cap exempt. Again, if you are interested, you can call our office and we would be able to work with you to have a conversation with your HR or your superintendent on how they would be able to be cap exempt. So cap exempt means you don't have to wait for March and April for the lottery. They could actually just file H1B any time of the year because they would be cap exempt. If your employer is cap exempt, they could actually apply for your H1B. At least you finish your J1 for a year, but do it before your third year expires or after your 2-year extension has been approved. If you are already outside the United States and you have not filed your J1 yet, they can actually file your H1 anytime. And if they are cap exempt, you would be able to have your H1 within a year if you do premium processing. If not, it will be 6 to 9 months. And then the challenge now, especially in the Philippines, is that their available schedule for H1B is now November. So we've been working with a number of school districts now, and we actually tell them, Nick, what's your guarantee that our teachers outside the Philippines, outside the US, will be here in August? We tell them impossible, right? Because while we can actually control the approval of the H1B by filing premium processing, we don't control how the US Embassy works in the Philippines. And as of now, H1B calendar is open up to, in November. So they might reopen as soon as the COVID situation in the Philippines improves, and I hope it would. But as of now, with the limited resources of the embassy, their available calendars for H1B is November this year. If they would want to apply for your immigrant visa, so this is actually a more complicated conversation because it depends if the school already had a labor certification approved and is still valid. If they do have that, you can apply anytime. But if they don't, it could take 18 months to 24 months before they could be approved of a labor certification. If you are outside the United States, the best route for you is to apply for H1B. Then after you are already in the United States on H1B, they can apply for a green card for you. Okay? So again, thank you for listening. I will now answer your questions based on those slides. Aidin, I am J1 subject to the 2-year rule, but my J2 dependents aren't. Can my spouse apply for H1? Or yeah, ma'am, it's possible though. I would recommend that you talk to an immigration lawyer to check what's the best option for you, right? So if you don't want to get an advisory opinion, there is still a risk that if your employer will file H1B for them, that they might be asked for an advisory opinion, or USCIS will say that, hey, we believe that you are subject to the 212E, and it's your responsibility to comply that you are not. Again, consult an immigration lawyer what's the best option for you. Lizelle, J1 was visa enrolled in graduate studies, then switch to F1 visa. Will she allowed to work full-time or be able to teach full-time? If J1 visa enrolled in a graduate studies, then switch to. So again, ma'am, if you are subject to the 212E, if you would apply to a student visa, they will look for a waiver. So after the J1 expires. Okay. Melody, I have applied for NOS and waiting for advisory opinion from the EVP. Can I still apply for? Yes. Ano pong timeline approval decision ng EVP under the guidelines? I don't think that they will be able to provide you decision 1 to 3 months. I hope so, but I'm not so sure about that. And can your citizen be passed for exception? Yeah, ma'am, there are cases that actually obtain exception hardship waiver based on having a US citizen child. Is that applicable for everybody? I don't think so, but you would want to pursue your option. What if from COA? What if I get married in the US, but he is under DACA? Is there a way to apply? Okay, unfortunately, ma'am, DACA recipients are not part of the ground or is not a reason to apply for exceptional hardship. I'm not subject to the 212E. I was granted an extension for 2 years. Right now, I didn't renew my contract to my school because I will be moving to another state. What will happen to my visa expired coming June? Okay, so ma'am, I would recommend that you consult us or consult an immigration lawyer because you you might have problems with the contract issues and you might have a problem with your J1 issues. Though we've seen a number of cases na wala naman naging problema, but to be in the safer side, I would recommend that you consult a lawyer in your case. Patricia, if your school district is willing to send you to school for postgraduate, master's, or doctorate, would that qualify for a waiver? No. Okay, Lois, 7 years na dito, wala bang ibang way na makastay? Unless you have a ground, ma'am. So if you are married to answer the question, yeah, if you are married to a US citizen, you have a way of staying. Okay, so guys, hindi ko na talaga masagot lahat, right? So I will just make this last question. And again, thank you very much for tuning in, everybody. Does this new NOS guidelines affect those who have submitted their application earlier, January 21 of this year? I don't think that they have the guidelines is saying that the EVP starts to accept NOS applications starting May 25, 2021. So if you have submitted it, the next question, ma'am, has the EVP accepted your application? Because my understanding is they did not accept NOS application before May 25. And once your application is accepted as of May 25, then you are now subject to the new guidelines. So again, maraming salamat everybody, and thank you for being with me for the last 1 hour and a half. So again, if you have more questions, send us a message or call our office or watch for my next video if we actually hear new development of any immigration update, whether it's coming from the Department of State or Homeland Security or from the EVP. Maraming salamat po. Good night.